It's time for a Legal Minute with the Law Office of Cooley Shrair in Springfield. Today we're joined by attorney Don McDonald. We're talking about non-compete agreements. A lot of people have them, a lot of employers make people sign them. What are they?
A non-compete agreement is an agreement whereby the employee agrees that it will not compete with their employer for a period of time after they're terminated.
And so depending on the employer, it could be a various amount of time, various locations of where you can or cannot work. But here's my question. Are they binding or enforceable? Say you leave your job and you want to take another one. How legal is this non-compete clause?
Well, the answer to that question is not black and white. It depends on many, many factors. In Massachusetts, they are generally considered to be enforceable. But I say generally because they could be too restrictive. And if they're too restrictive, the courts will not enforce them. So, for example, if you have a time limitation of 1 year and you can't work anywhere in the state of Massachusetts, a court would probably find that to be enforceable. However, if the period of time was 5 years and you couldn't work anywhere in the world or anywhere in the country, a court may say that's too restrictive. You have to allow the employee a way to earn a living.
I understand. Now, lastly, if an employee is presented with one of these, what should they do? Should they sign it immediately?
They should not sign it immediately. They almost always do, but they should never do that. They should call an attorney and ask them what they're agreeing to, how restrictive it will be, because they have to understand the ramifications if they lose their job, how they're going to earn a living in the future.
That's true. Don, thank you so much. It's a pleasure having you here today. That's your Legal Minute. And for more information, you can go to cooleyshrair.com.